At this time, I'd like to reserve 2 minutes of my time for rebuttal.
2 minutes.
Yes,
okay.
please. May it please the court, good afternoon. My name is Catherine Driver. I have the honor of representing the appellant mother in this matter, Miss Danielle Goynes. On behalf of Mother, I appear before you today to request that this court reverse the decision of the trial court to modify an agreed permanent parenting plan, a decision which changed the primary residential parent designation as a discovery sanction in a default judgment. The trial court's decision in this matter was flawed, and because the final judgment from which Mother appeals was a default, the record and the proof that for this court to consider are relatively limited when viewed in relation to the consequences of that decision. Today, there are several issues that I want to discuss with you, and I'm afraid that I won't have time to discuss all of the issues raised in our brief. In preparing my remarks today, I chose to think about the issues in this case in 2 categories. The first category being the jurisdictional issues, and the second category being the issues with the default judgment itself. The jurisdictional issues include summary judgment and inconvenient forum. And the issues with the default revolve around whether the trial court abused its discretion in its determination to deny the mother's Rule 60 relief, and whether the discovery sanction was appropriate in this matter. I plan to spend most of my time on the jurisdictional issues, so unless there's an objection, I'd like to start there. The trial court did not have subject matter jurisdiction in this matter to modify the existing the 2021 parenting plan. The trial court did not expressly consider this. It was raised in a motion by Mother's prior counsel, and then there was a hearing on an inconvenient forum argument. The trial court, after that hearing, concluded that the presentation was inadequate on subject matter jurisdiction, and the trial court determined that upon the agreement of the parties, it had subject matter jurisdiction. But I want to walk through the steps under the UCCJEA that the trial court should have considered. There are 3 ways, as you know, that a court may have custody jurisdiction: initial jurisdiction, continuing jurisdiction, or emergency jurisdiction. Continuing jurisdiction is, Tennessee has continuing jurisdiction if neither the child nor the child and one parent have significant connection with the state, and that substantial evidence is no longer available in Tennessee concerning the child's care, protection, training, and personal relationships. And candidly, in evaluating this test, I could not find a definition or a metric on which courts agree that a significant connection exists. The significant connection facts in this matter are Mother and the minor child moved to Texarkana, Arkansas by agreement in June of 2021. By January 2022, Arkansas had become the child's home state. That's where the child lived for at least 6 months prior to the filing of the petition to modify. Father filed the petition for criminal contempt and to modify on August 29th, 2022. Approximately 14 months after the mother and the minor child moved to Arkansas. Mother and the child returned to Tennessee for one visit in 2023, the December Christmas holiday, but at the time of the filing, the minor child had only returned to Tennessee for father's visitation. After considering the significant connection factor, the court must then turn to whether substantial evidence is held in Tennessee. So if Tennessee no longer has substantial evidence concerning the child's care, protection, training, and personal relationships, then continuing jurisdiction is lost in Tennessee. Those substantial evidence facts almost exclusively were in Arkansas by the time that this was filed.
So the appellee in their brief points out that your position is inconsistent with the decision in Parker against Parker.
Correct.
Was Parker against Parker wrongly decided?
I wouldn't be critical of Parker v. Parker. I think that this is a fact-specific issue. And when you look at the facts of this case, the minor child was there for over a year. She was established. She was in school. That's in the record.
So what do we do, though, with the comments in the UCCJEA that speaks to exactly this issue, that a court is not deprived of continuing jurisdiction if one parent and a child moves to a new jurisdiction?
It's not solely based on the move. It's based on the lack of significant connection and the lack of substantial evidence. I think that the substantial evidence had to be in Arkansas, given the recency of the child's move. All of that evidence is there.
So is it, in your view, is the statute, do you read it then as a balancing which jurisdiction has more evidence than the other? I mean, clearly some evidence is in Tennessee because the father remains here. So, I mean, you're going to take some evidence from the father as well. So, I mean, is that not substantial?
No, the balance comes in the later point, which is the inconvenient forum. So, the father's relationship.
Which, as I understand it, that's a separate argument on your part beyond just subject matter jurisdiction.
It
You're
is.
saying even if subject matter jurisdiction exists here, it's still an inconvenient form.
That's correct. And I don't want to minimize the father's relationship, and I understand that I'm getting close on time, so I want to move to my next point if that's permissible. But did I answer your question adequately? Okay. So if substantial evidence is in Arkansas, the child does not have significant connection, then it becomes necessary to move to whether the Tennessee court would have initial jurisdiction. And that is under TCA 36-6-216. That is when the state is the home state at the time of the commencement of the petition to modify. In this case, that was Arkansas at the time that we're talking about in 2022. And then a court of another state doesn't have home state jurisdiction, or the home state has declined to exercise jurisdiction. We have no information about whether Arkansas considered or was asked to assume jurisdiction in this matter. So moving to the inconvenient forum argument, which Justice Breyer, I believe, is going to speak more to the question that you asked. The trial court expressly considered and reached an illogical result in this case. Below, this is an abuse of discretion review at this point, and abuse of discretion occurs when the trial court applies an incorrect legal standard, reaches an illogical result, resolves the case on a clearly erroneous assessment of the evidence, and causes an injustice. And I believe the appellee's brief indicated that we did not complain of an injustice. That could not be further from the truth. Mother was burdened with finding child care for the minor child who was a resident of Arkansas, participating in litigation in Tennessee. There was an extreme injustice in that. She was absolutely burdened, and we do complain of an injustice. The test for an inconvenient forum is set forth in TCA 36-6-222B, and it requires the examination of 8 different factors. Some of those we agree are not at play. Do you have a question? Okay. The first is the length of time that the child resided outside of the state. I would offer that although, relatively speaking, when you're looking at the lens of the life of a 14-year-old, a year does not seem like very much. She lived there for over a year. She was involved in school. She was involved in extracurriculars. She was immersed in her community there. And so that factor weighs in favor of Arkansas. The second factor, factor 2, is not implicated in this matter. Number 3, the relative financial circumstances of the party. As I mentioned, mom was the primary residential parent through the 2021 order, and she suffered a great expense, the burden to travel to and from, to find childcare for her daughter when she would need to be out of state to litigate this case in Tennessee was an undue burden that she shouldered. Additionally, I would point out that the financial burden of hiring new counsel, which is what the trial court relied on, is unreasonable. Litigation is expensive no matter where you are, and the additional cost of finding new lawyers in a different state is likely not more than it is here.
So what's the argument for imposing all these extra expenses on the father as opposed to mother?
The argument is that he was not the primary residential parent. He did not have the additional child care burden of finding someone to watch and leave his child at that time. And the other factors that I want to discuss, including the nature and location of the evidence, all in Arkansas. So when you view that financial burden against the concentration of information in Arkansas, that's when this decision becomes illogical or unreasonable. So there was an agreement of the parties as to which state, there was no agreement of the parties as to which state should assume jurisdiction. However, there was an agreement allowing mother and the child to move there. I think a logical conclusion that can be drawn from that is that Arkansas is best situated to make determinations about the child moving forward. And then the ability of each court to decide the issue expeditiously doesn't favor either. Whether domestic violence has occurred and which state would best protect the parties and the child. This is an issue that I really want to touch on because there are allegations of domestic violence in this case. They involve the mother's new husband. That person is an Arkansas resident living in Arkansas and a person who was in the home with the minor child. So it's important that we address that. However,
Counsel, are all of the allegations related to domestic violence in Arkansas? Don't they start in Tennessee?
they do start in Tennessee, but I would counter that information is available in the record and would be available to the Arkansas court who received it upon transfer. So I don't think that there are any new facts coming out of Tennessee because the parties have moved, or the mother and the stepfather have moved. So no new information would be available in Tennessee on the domestic violence issue. Additionally, the last factor, and I'm running out of time, is the familiarity of the court with the facts and issues. I don't think that favors either, and that's because the court has changed significantly over the course of the litigation here. The litigation in this case began when the child was born in 2010. The judge sitting in the court has retired since then, and the new judge who heard this matter it just gets the facts on the record. That's it. Those are the balance of my jurisdictional points, and with that, unless there are any further questions, I'll conclude. Thank you.
Thank you.
Good afternoon, and may it please the court, I am Jeffrey Payne of the Rutherford County Bar, and I represent the appellee father in this matter, Bryan Hibdon. So this is a custody case, but this appeal centers not on the substantive merits of custody, but on the procedural integrity of the trial court's decisions, which were in part necessitated by mother's abject failure to meaningfully participate in the process. Today, I'd like to focus on two key points. The first will be the trial court's proper exercise of jurisdiction under the UCCJEA. Second will be the propriety of the default judgment, especially given the baseless and inconsistent assertions in the affidavit from mother's trial counsel, which attempt to mischaracterize the trial court proceedings. So to begin with, regarding the application of the UCCJEA to this case, this issue actually has two subparts. The first concerns jurisdiction pursuant to 366217A1, which contains these dual requirements of significant connections and substantial evidence. Now, despite mother's argument in her briefing that the former is a threshold question that must be affirmatively found before moving on to the latter, I found no law to support this assertion. In fact, the official comments of this statute are pretty clear that only when the relationship between the child and the person remaining in Tennessee has become so attenuated that the court can no longer find significant connections and substantial evidence, would it then be appropriate to find that jurisdiction has been lost? Regardless, we believe that both of these dual requirements are met in this case. The child in this case had only resided outside of this state for barely more than a year before the filing of father's petition, and the child maintained significant connections with this state through extensive visitation with father at his home in Smith County, Tennessee, throughout this time period. Substantial evidence regarding this matter also remains available in Tennessee regarding the exchange of the child and the abusiveness of mother's husband. Mother's briefing on this issue focuses heavily on the 2008 case of Graham v. Graham to support her argument that the child no longer has a significant connection to this state. The more recent 2019 case of Parker v. Parker makes it clear that mother's reliance on Graham is misguided. In Parker, one of the parents made the same argument that mother does here, basically that the child's only connection to Tennessee was via visitation with a parent. The Parker court was clear that this is not the state of the law when they clarified, and I quote, "To the extent that our decision in Graham can be read to hold that a child cannot maintain a significant connection with Tennessee through regular visitation with a parent who still resides in Tennessee, we disagree. Regular visitation may foster a continuing relationship between the child, the parent, and this state." And that's exactly what we have here in this case. Very regular visitation between the father and the child in Tennessee, including holidays, spring, fall, Christmas, and summer breaks, as well as one weekend per month. So essentially, mother has failed in her burden of proving that the child's relation to this state is so attenuated that this state should no longer retain its subject matter jurisdiction. The trial court properly retained jurisdiction pursuant to 36-6217, and that decision should be affirmed. Now, the second subpart of this UCC-JEA issue deals with the inconvenient forum statute, 36-6222. The trial court properly considered all of those 8 statutory factors, and no portion of its reasoning could fairly be characterized as an abuse of discretion. The trial court's conclusions were logical and reasonable, and they aligned with both the evidence and the law. The trial court properly determined that Tennessee was not an inconvenient forum pursuant to the statute, and that decision should also be affirmed. Now, moving on to the second key issue that I would like to address, this issue deals with the propriety of the default judgment that was entered in this matter.
Could we, rather than go to your second issue, could we talk about the third issue and the best interest analysis here?
Sure.
You have suggested remedy. You have not suggested that we should soldier on in this case, but rather the appropriate remedy is to vacate, keeping the current plan in effect. Why is that the best approach in the case?
Well, I mean, I think the key thing is, and this aligns with all the case law that I've read on the issue, is that the trial court just didn't go through the factors. You know, you've got those 16 factors in 106 and 36-6106, and for whatever reason, the trial court just didn't do that. And I think from all the case law I've read, it seems as though that sort of robs the Court of Appeals of its ability to soldier on. So I wouldn't try to argue for a remedy that's inappropriate or not supported by the case law. The only thing that we put forward as far as what the remedy we think it should be is that we don't think it should be sent back and just all of a sudden, because at this point the child has been residing with father for going on a year. So it would be, I think, very disruptive to just go back to the way things were prior to the entry of the default judgment. And I think the more appropriate remedy there would be to leave the current plan in place as a temporary plan, give the trial court some time to do whatever it needs to do to go through and do a proper evaluation of those factors. And then if the trial court, after having gone through those factors, if it decides that the child should stay with father in Tennessee, or if it somehow changes its mind and decides that the child should go to Arkansas with mother, then the parties can appeal that ruling.
Counsel, the motion to withdraw, or the second motion to withdraw, is set the same day as the default hearing in this case, right? And the motion provides for 30 days for mother to obtain new counsel. So mother's looking at a situation which she has representation going into the default hearing. The motion to withdraw, my understanding, correct me if I'm getting any of this wrong, the motion to withdraw is granted. The judge X's out the 30 days. And
just to a minor correction on that point, what happened was the trial counsel requested permission to strike that provision himself, and then the trial court granted that permission, and then trial counsel proceeded to strike that provision from his order that granted his withdrawal.
So going into the default hearing, though, mother has available to her a motion to withdraw by her counsel that says 30 days for her to find a replacement attorney. And what ends up happening instead is we have a grant of the motion to withdraw with the 30 days disappearing, and a hearing where you either thought you were going to have 30 days or you're going to have counsel representing you. You have no counsel representing you in that hearing. And that seems like a fairly dramatic change from mother going into a default hearing. I thought I was going to have representation. I thought I was going to have 30 days. Why isn't that problematic here in entry of a default?
Well, okay, so as a first point, she was represented. The reason I believe that he
Is she represented in the hearing, the default hearing?
Oh, absolutely. Trial counsel presented extensive argumentation. He argued for why the default shouldn't go down, for alternative remedies. He argued about how, default is an extreme measure and it should only be used in extraordinary cases. He presented full legal argument, and it was only once the trial court had said, okay, well, and they had heard legal argument from both sides, from both the mother's counsel and the father's counsel, legal arguments on whether or not default judgment is appropriate. And once the trial court said, okay, I've heard your legal arguments on whether or not this is appropriate, I find that default judgment is appropriate, and I'm going to move forward with the evidentiary portion of this hearing, and we're going to hear some witnesses, and we're going to do all that. But I am moving forward with this, and it was only at that point that mother's trial counsel asked to leave the courtroom and asked to have his order signed, because at that point he had, I suppose to his mind, he had lost the case at that point, and there was no need for him to proceed. It wasn't really clear to me from the record why he would leave at that point in the case. But he did represent, and of course he never brings up any of the issues that are argued that he later puts into his affidavit about how he got no notice, and that the mother would have been there if she'd have gotten notice. Well, he never brings that up.
I mean, so does the affidavit say that he received no notice or his client received no notice?
I believe it said he received no notice.
He received it, okay, despite the certificate of service on the motion.
Exactly.
Okay.
And then he shows up in court and he doesn't, it's announced from the very beginning, hey, we're going to be doing default judgment today based on this missed deposition. He never brings it up. The trial court even points out to him, your client's not here, right? And he never says anything about it. He never raises an objection. He never raises anything having to do with the lack of notice.
In the hearing, the evidentiary hearing, I'm trying to make sure that I've got the timing on this correct. The evidentiary hearing on the motion itself was scheduled for that same day, so the motion for default was noticed up for hearing to occur simultaneously or on the same morning as the hearing on the motion to modify. petition to modify.
Right. It was all to be resolved the same day.
Same day, okay. And so counsel was still engaged, at least through the argument on and then the court announced its decision that he was going to grant default, and at that point, he said, I withdraw.
Right. He said, well, if I may have permission to leave, and he said something about the order. I've got this order prepared. Do you want me to just strike through this part, giving her another 30 days to get a new attorney? Because at that point, the case is over, I guess. I guess that's what he's thinking.
Okay.
So he strikes it, and you can see it in the record. You can see the order with the line marked through it, plain as day. And there's other issues with this affidavit. I believe we touched briefly on this. He swore in his affidavit that he would have remained on the case if the trial court intended to proceed with the default, and that he left the courtroom under the impression that the default would not be heard. And as we've just talked about, the transcript is abundantly clear that default was on the table from the very beginning of that hearing. Trial counsel put on his argumentation. Both sides did, and like I said, only once the court said that it was moving forward did he ask permission to leave the courtroom. There's another claim here that's completely debunked by the transcript. Mother's trial counsel swore in his affidavit that he left the courtroom under the impression that Mother would be afforded another 30 days. And like we've discussed, that's just not what happened. He struck through that order himself. He presented it to the court. And one of the problems that I think I have with this, so when trial counsel drafted this affidavit, he didn't have the benefit of reviewing the transcript because the transcript hadn't been produced at that time. But here we are on appeal, and we're still pushing this affidavit as really the only thing that supports. There's no support anywhere else in the record for Mother's assertions upon which she bases this argument that the default judgment was improper. It's all in this affidavit. And now that we can compare side by side the affidavit and the transcript, we know that things in this affidavit are false, yet we're still pushing this affidavit. And so my position on that would be that these inconsistencies just totally undermine the credibility of this affidavit. I don't think there's anything in there that we can reliably look to as a factual assertion of what actually happened in this case. So I believe that's all I have, unless there's any further questions.
Okay,
I
well,
appreciate- Sure.
yeah, I've still got questions because I'm looking at the transcript now, and the court says next on the docket is the matter of Hibdon versus Goynes. Well, counsel, I think I kind of know what's going on here. I know we've got a trial set for Friday, but Mr. Palumbo has a pending motion to withdraw. Ms. Young, you have a motion for default today based on deposition, I believe. Is that correct? Ms. Young replies, yes, that's correct. The court, okay, any objection to him withdrawing at this point? Ms. Young, no, Your Honor. And the court says, I'll grant that motion. I mean, that's on page 2 of the transcript. So it looks like to me the timing is reversed in what you've told us. I appreciate that Mr. Palumbo stays around in the case. I'm just confused about the timing here.
Sure, and I'm not sure whether the trial court maybe meant to say that I will grant, because regardless of whether or not the motion to withdraw was granted at the very beginning or right before Mr. Palumbo left, he still advocated for his client. quite extensively throughout.
Yeah,
that-
I mean,
that
I see
hearing.
that. It's very odd because he says, first he says, I'm not here for the default hearing, but then he says, but going forward on a default hearing today, that would be not the appropriate approach in this situation. And he's arguing, this is very odd.
And you'll note throughout that whole thing, never once does he say, we got no notice. My client I was just here to withdraw. We had no idea that there was a default today. That never happens. Thank you.
Thank you.
Briefly on rebuttal, I want to make it abundantly clear, Mother was not represented at the time of the default hearing. Mr. Palumbo withdrew first, as you accurately read from the transcript. Representation requires inherently the ability to cross-examine witnesses. Mr. Palumbo offered argument on behalf of his client as he was walking out the door, but she did not have significant and beneficial representation at the time of the default hearing. The default hearing should not have gone forward on January 23rd. And the trial court, did not determine that it was in the best interest of the minor child. His ruling that day was intended to punish Mother. It was a discovery sanction. That was the purpose for the default.
Yeah, but the way the court is ruling here, it makes it sound like the court feels like your client had representation for that component. It says, I'm going to move forward on the default today, Ms. Young. Again, it will be in the order. This is not Mr. Palumbo's fault. He's done everything he's supposed to do as counsel. But I'm going to allow you to withdraw, Mr. Palumbo, but we'll move forward on the default today. I mean, this is just very unusual.
I don't disagree. But Mr. Palumbo did not have the opportunity to cross-examine Father in his later testimony at the default hearing. He was not afforded that opportunity. He left the courtroom because it was his impression that he had withdrawn. That's reflected in his affidavit. The trial court prioritized its ability to punish Mother over the best interest of the child in this case. And that is for no other reason why this needs to go back.
So when Mother moved to set aside the default here, what rationale did she give for the underlying basis for the default here?
The underlying basis for the default hearing was mistake. It was inadvertent.
Well, what about the deposition, though?
No, to my recollection, no testimony was offered.
I mean, doesn't that have to be, if you're moving to set aside default, it's not enough to say the default was improperly granted. You've got to also say, I've got a meritorious defense to the default. Because you were not going to waste the court time setting aside a default if you're right back where you started from. And so here, I think it would have been incumbent on the mother to at least explain, well, this is why I didn't show up for the deposition and participate in discovery. I mean, what was the excuse there?
Well, the argument on the Rule 60 motion was based on her excusable neglect for her absence on the day of the default. We did not present additional
So really,
argument
mother didn't do what
regarding the deposition
she needed to do to set aside a default then by not showing that she had a meritorious defense.
I'm sorry?
So basically, mother did not do what she was supposed to do to show that she had a meritorious defense as a basis to set aside the default, because that's a component of it.
I disagree that she didn't do what she was supposed to do.
Okay, so what was what was the excuse then for not showing up at the deposition or participating in discovery?
Her excuse for not showing up at the deposition was that there was weather. It was scheduled 2 days after New Year's, and that's the excuse. She lives.
But was that
less than
presented to the court as part of the attempt to set aside the default?
We didn't get there. He didn't want to hear it. Thank you.
Thank you. Thank you both. Would you call the next case, please?